Business Law Corporation Part 1. Definition: a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. The corporation herein defined refers to a private corporation. Attributes of a corporation. Based on its definition, the attributes of corporation are: it is an artificial being. An artificial being, it has a personality separate and distinct from stockholders, and just like a natural person, it has the right to acquire and possess properties as well as incur obligations. The stockholder and the corporation are not considered the same pursuant to the doctrine of separate entity. However, pursuant to the doctrine of piercing the veil of corporate entity, the separate personality of a corporation may be disregarded, and the stockholders and corporation may be considered the same if valid grounds exist, such as when a corporation is established to defeat public convenience, to justify wrong, protect fraud, or defend a crime, or when it is merely served as an alter ego of a person who has full control of its funds. It is created by operation of law. Unlike the contract of partnership, a private corporation cannot be created by mere agreement of the parties. It cannot also be created by law, unlike public corporations and government-owned corporations. It can only be created by operation of law or by complying with the provisions of a general law authorizing its organization. It has a right of succession. A corporation continues to exist until the expiration of its term, unless sooner dissolved in accordance with law. The changes in its membership, such as death of the stockholder or the transfer of shares to another or the withdrawal of a stockholder, does not dissolve the corporation. It does not mean, however, that the corporation can exist forever. It only means that its existence is independent from the existence of its stockholders or members. It has the powers, attributes, and properties expressly authorized by law or incident to its existence. The powers of corporation are classified into express power. These are the powers of authority expressly granted by law to the corporation or expressly contained in its articles of incorporation and bylaws. Incidental powers. These are powers which a corporation can exercise as an incident to its corporate existence, such as the power to issue shares of stock, to sue and be sued to adopt bylaws, and to elect corporate officers. Many of these incidental powers are already included in the express power of the corporation. Implied powers. These are the powers which a corporation may exercise, although not explicitly granted, in order to be able to carry out its express powers. Example: X corporation is authorized by law to engage in land transportation business. As such, the corporation has the authority to buy transportation vehicles, although it is not explicitly mentioned by law nor stated in articles of incorporation, because these vehicles are necessary to execute its express power. Corporation acts which are legally authorized or within its express, implied, or incidental power are called intra vires acts. Acts done by corporation which are not within its express, implied, or incidental power are called ultra vires acts. Ultra vires acts are not always void. If the ultra vires acts of corporation are not contrary to law, morals, good customs, public order, and public policy, said acts are only unenforceable, and all the stockholders may ratify the same expressly or impliedly. Advantages and disadvantages of a corporation. The chief advantages of a corporation are: the opportunity of any number of persons to unite in single enterprise in anonymity to cooperate in furnishing the large amount of capital necessary to finance the gigantic enterprises of modern times. The capacity to hold property, to contract, to sue, and be sued as a legal unit or distinct entity. The exemption of the stockholders from personal liability in excess of their investment in the corporation. The continuity of corporate existence regardless of death and changes in its membership. The facility of transferring the stockholders' interest or investment in the corporation, and there is a greater source of capital. Notwithstanding the foregoing advantages of a corporation, it has the following disadvantages, to wit: the corporation is relatively complicated in formation and management. It entails relatively high cost of formation and operation, and there is a great degree of governmental control and supervision than in other forms of business organization. There is a lack of personal element in the view of transferability of share and the vesting of management powers in the board of directors. Minority stockholders have very little voice over the conduct of business of the corporation. The limited liability of the corporation has often been abused, and it provides inadequate protection and compensation for victims of business ventures. The corporation is subjected to heavier taxation because the profits of corporation, which is already subjected to corporate income tax, are again subjected to income tax when declared and distributed as dividends to stockholders. A corporation cannot engage in business other than business specified in the articles of incorporation. Corporate formation. The three steps in corporate formation are promotion, organization, and commencement of this business. Promotion is the process by which a corporation is brought into existence. It includes the offer to form corporation and procurement of subscription from its purpose authorized capital stock. Incorporation is a process of acquiring legal personality beginning from drafting of its articles of incorporation up to its approval by the Securities and Exchange Commission. A corporation may be formed but not less than 5 but more than 15 incorporators who must possess the following qualifications. All must be natural persons. All must be capacitated. Majority must be residents of the Philippines, and all must be subscribers of at least one share of stock. No minimum capital stock is required except if provided by special laws, as long as the paid-up capital should not be less than 5,000. 25% of authorized capital stock must be subscribed, and 25% of subscribed capital stock must be paid up, but in no case shall the paid-up be less than 5,000. For example, the authorized capital stock of the corporation is 75,000. 25% of the authorized capital stock, or 18,750, must be subscribed, and 5,000 must be paid up. Here it is not proper to follow the 25,000 subscription and 25% subscription and 25% paid up, because doing so will result in the amount of 4,687.50 as paid up capital, which is not allowed by law. This requirement by the law regarding the amount subscribed and paid up must be stated in treasurer's affidavit attached to the articles of incorporation. A private corporation formed or organized under corporation code commences to have corporate existence and juridical personality and is deemed incorporated from the date of Securities and Exchange Commission issues a certificate of incorporation under its official seal. Organization and commencement of business. Organization refers to the formation of the corporate organizational structure in order that the corporation can start its business, such as election of its officers. Under the law, the corporation is given a period of 2 years from time of issuance of certificate of incorporation within which to formally organize and commence business. Failure to do so, the corporation is considered dissolved. If a corporation started its business within a said 2 years period, but it stopped operating and remained idle for at least 5 years, it is considered a ground of its dissolution. The foregoing rules shall not apply if the failure of the corporation to formally organize within 2 years or failure to operate continuously for 5 years is due to fortuitous event. Corporate bylaws. Bylaws are rules and regulations adopted by the stockholders or members of the internal government of the corporation. It may be filed at the Securities and Exchange Commission before or after the incorporation. If it is filed before the incorporation, it must be signed by all incorporators, but if it's adopted after the incorporation, it must be approved and signed by majority of the outstanding capital stock or majority of the members. If the bylaws are not filed before incorporation, the law requires the same must be adopted and filed within a month from the receipt of official notice of issuance of its certificate of incorporation by the SEC. The adoption, amendment, or repeal of the bylaws may be delegated to the board of directors or trustees by a vote of 2/3 of the outstanding capital stock or 2/3 of the members, if non-stock. For the revocation of the authority delegated to the board, a majority vote of the outstanding capital or member is necessary. Different kinds of corporation. Corporation aggregate, which is composed of more than one stockholder or member. Corporation sole, one which is composed of a single member. Ecclesiastical corporation, one established for the public worship of God. Lay corporation, one established for temporal purposes and is composed of laymen. Stock corporation, one which has capital stock dividend into shares and authorized to distribute dividends to its stockholders. Non-stock corporation, one in which there is no such stock. De jure corporation, one created in strict or substantial compliance with the law. De facto corporation is one defectively created or incorporated under the existing law with a certificate of incorporation and actual exercising its corporate powers. Eleemosynary corporation, it is one created for charitable purposes. Civil corporation is one established for business transactions. Public corporation, one formed as organized for the government of a proportion of state. Private corporation is one organized wholly or in part for purposes of private emolument. Domestic corporation in relation to particular country, it is one which is incorporated or existing under the laws of that country. Foreign corporation, under the corporation code, it is one which is incorporated or existing under the laws of another country, which allows Filipino citizens and corporations to engage in business in their territory. Open corporation is one where the public may become stockholders or members. Corporation, closed corporation, one which stockholders are limited to few persons not exceeding 20 and whose shares of stocks are not open for subscription to the public. Parent or holding corporation, one related to another corporation that has power to elect the majority of directors of such corporation directly or indirectly. Subsidiary corporation, one related to another corporation that a majority of its directors can be elected by such corporation directly or indirectly. Wasting assets corporation is one the sole purpose of which is to invest its capital in a specific property and to consume that property or extract its value for profit. Affiliated corporation is one related to another by owning or being owned by common management or by long-term lease of its properties or other control device. Government-owned corporation is one which is wholly owned by the government. Government-controlled corporation is one which the government is the majority of stockholder. Corporation by prescription, one where corporate power have been exercised by a body of men for such a long period of time as to raise a presumption of the grant of an incident charter to their predecessors. Corporation by estoppel is one which is not really a corporation but represented itself to the public as a real corporation and which cannot be allowed to deny such representation for protection of innocent third persons. Quasi-public corporation is a private corporation with a franchise or contract granted by the state for performance of public duties. Quasi-corporation, one which is not corporation in a full sense but is invested by law with some of the attributes of corporation, as the capacity to sue and be sued as a corporate body, to have a right of succession or to make particular contracts or hold particular properties or rights as a corporate body. Trading corporation, one engaged in the business of buying and selling. Test of corporation nationality or citizens. The tests of determining the corporate nationality or citizenship are: incorporation test. A corporation is a citizen of a country under whose laws it has been incorporated. Control test. The nationality of a corporation is determined by citizenship of its controlling stockholders. The domicile test. A corporation is a national or subject to jurisdiction of a place where its principal office or center of management is located.